Good evening. It's Thursday, September 19th, 2024, 6 p.m. We are the City of Franklin Plan Commission. Mr. Martinez, would you please take the roll?
Mayor Nelson,
Here.
Commissioner Shago,
Here.
Commissioner Haley is excused, City Engineer is excused, Alderwoman Day,
Here.
Commissioner Leong is excused, Commissioner Specht.
Here.
Excellent. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we're going to go to item B, approval of the minutes. Approval of the regular meeting of August 22nd, 2024. Is there a motion?
Move to approve.
Second.
First and a second. Any further discussion? So I'm going to say this once for the entire night. The chair will be voting, not to say every single time, like Groundhog Day. Any further discussion? No? All those in favor? Aye. Any opposed? I say the motion carries. Under C, there's no public hearings. Under D, citizen comment period, citizens may comment upon the business matter items set forth on this meeting agenda. And we've got two. If anybody wishes to speak on these two, please approach the podium. State your name and address for the record. If there is... Dana, good evening. Go ahead.
Finish your speech. Okay, Dana Gint, 9011 West Hawthorne Lane. I'm on the Ordinance Task Force Citizen Group, so that's why I'm here tonight. I do have a bunch of comments on certain sections, so I didn't think it was, I don't think you want me to go through every section. I was wondering if there's a possibility as they're doing the presentation, if I have a question or concern, can I bring it up at that time instead of standing
I
up
would
here?
think that's the most prudent thing
Yeah, okay.
as it's gone through tonight.
Because otherwise it'll be very confusing. Because Kelly printed this UDO book for me, which is awesome, but their pages don't correspond with what's on the agenda. So it's very I need to sit and go through as you guys are presenting stuff. So, but I appreciate that. So if I could do that, that'd be great. Thank you.
Yes, I believe that would be the most prudent thing. So, and thank you for your efforts on the UDO rewrite.
Okay, thank you.
Anyone else wishing to speak at this time? Seeing no one else? Close citizen comment period. Now we'll go under E. Edward, Business Matters. Recraft and Relic temporary use request to allow for a 2-day indoor ticketed curated shopping event on 3 separate weekends, November 9th and 10th, February 1st and 2nd of 2025, and April 5th and 6th, 2025, on property located at 6000 West Ryan Road, tax key number 882-9987-001 and 852-9999-001. I don't have the update who's taking this one. Oh, good evening, Ms. X. You've got the floor.
Good evening, Mayor, and thank you. So this item is a request for a temporary use for multiple dates for the Recraft and Relic event at the sports complex off of Ryan Road. This event has been held at that location for a number of years now and has proved pretty successful. The dates were described in the agenda and also in the report, but I will note that the applicants will be on site also for setup and breakdown outside of business hours. So it does encompass that time period. The only change between this year's request and previous years is that due to the success of the event, they have had to organize off-site parking in order to accommodate some of the overflow parking. So they've arranged for off-site parking with Lubrizol, which is located in the business park. They have a very large parking lot, which is more than adequate to, accommodate this. And they did provide, it had been a condition of approval in the draft resolution, but the applicants did provide confirmation and authorization for the use of that holiday market parking space for the November event. So we would request that the condition apply, no longer apply to that date. And we recommend approval of the application.
Excellent. Any further discussion? Is there a motion to approve?
I'll make that motion. Second.
First and second. Any further discussion? Seeing none, all is in favor?
Aye.
Any opposed? Ayes have it, motion carries. Well done. Point number 2, Unified Development Ordinance UDO Rewrite Task Force, Article 9, Administrative Standards and Procedures, session prepared by planning staff and project consultants, Dussel Levine Associates and Birchline Planning LLC. Who's leading this ship?
Good evening. Just to introduce again Jackie Berg with the project consultant. Also, Levine will give a presentation of this article. So I yield to
Excellent.
Jackie.
Good evening and welcome, Jackie. If you just, for the record, just state your name and business address for the record. You're on. And bring it close like it's
Right now.
Right there.
Right there.
like karaoke. Like karaoke.
Okay. Jackie Berg with House of Levine. We're at 188 West Randolph Street in Chicago.
Thank you.
So thank you all so much for having me here again this evening. I think this will be our last task force meeting to go through the UDO. So this evening we would like to go through Article 9. So this is the administrative procedure. So really how development is reviewed and approved here in Franklin. So we know you all have had a chance to review the article. So we really just want to focus on our policy discussion questions that we included at the end of the memo that this chapter was sent along to you all with. But before we get into those questions, if you all have any questions for me, anything that you would like to clarify within the article itself, happy to do that before we get down into the policy discussion.
So at this time, I'd like to open up to members of the commission here, or if there's a staff that wants to put input at this point in time. And then we'll move on to the citizen, Ms. Gint, who's involved on the task force team. And that's a bee, by the way. So if anybody's got allergies to a bee, that's the bee flying around. Counselor, you've said something? Okay. I guess continue. I don't have nothing right now.
Okay, awesome. So the first question we want to bring to you all is about the Architectural Review Board. So in previous phases of the project, we've discussed eliminating references to the Architectural Review Board from the standards. So the board doesn't currently exist, but we just wanted to make sure that that isn't a board you all would want to see exist in the future and have a role in the development approval process in Franklin.
Just a correction there. The Architectural Review Board exists. The issue is that the ordinance does not have clear architectural standards for residential. So that's the main issue. It's not staffed by the planning department. It's staffed by the inspection services department.
Okay.
So we consulted with inspection services about eliminating that process of the Architectural Review Board. They kind of concurred, because the applications are presented before the Architectural Review Board, but there are no clear standards. So basically, the review is kind of unnecessary in a staff opinion. So that's why we're recommending to remove that step for residential building permits.
Okay. Is this the attorney? Give him
City Attorney Rademacher has been doing the detail review on this subject. And I actually said, what? When I looked through his brief summary today and mentioned that to him. But with regard to the Architectural Review Board, he briefly states, having an Architectural Review Board may have the effect of turning a permitted use into a conditional use. The Architectural ARB has power over all applications, including those for permitted use. Additionally, the Architectural Review Board shall not approve any application unless they find beyond a reasonable doubt, that's a criminal standard, that the following facts and conditions exist and shall so indicate in the minutes of their proceedings. This is a very high burden of proof, et cetera, et cetera. So he was not a fan of continuing an Architectural Review Board.
Agreed.
My comment to him was, I think it's been there forever. I've never dealt with it, though.
Probably.
Correct, yeah. So
And I haven't heard of any issues that arose from it.
the draft article that you have has the Architectural Review Board, but that's why the question is to eliminate that process.
Jackie keeps nodding her head.
If you guys are down for it, I do think it would help streamline things. Like you said, make sure that our permitted uses continue to be permitted and not have conditions that we don't intend to be applied to them.
I'll start, I guess. I'll give 2 cents. I absolutely want streamline, less tape, bureaucratic stuff, so that's my take on this. Does anyone else wants to chime in on this?
I agree.
Okay, we can continue.
All right, very good.
Now, Dana, at what point do you want to start? Okay. Okay.
Next thing we wanted to discuss with you all were some proposed changes to the site plan review process. So we are proposing that more site plans be able to be approved administratively rather than having to go in front of the Plan Commission, in front of you all for approval. However, there is a kind of exception in that so that the zoning administrator is able to kind of refer any site plan to you all for review if they feel that's necessary. So they have that like in their back pocket. And I'm sorry, it's for a proposed development that results in a change or addition of 100,000 square feet or more. So that's when you all would get involved in the process, and we wanted to make sure that this was the correct threshold. If you all wanted to be involved on smaller projects, larger projects, or if we hit the right spot.
Just for illustration, so projects like big box like Karma development or likewise, these big buildings will still go to Plan Commission. But a small restaurant or a small shop will go through the administrative process through staff.
And then that's a streamlining effort?
Yes.
Fewer
So-
meetings.
What's that?
Fewer meetings to get through approval.
Right, I mean, so it's gonna still have a checks and balances, but just, okay. Alderwoman Day?
Is that just for the site plan? So if there are other things that were coming up with regard to that particular building, say for example, it needed a natural resource protection, something that would still come here, it's just the site plan that would skip over this, or would all things kind of skip over it based on the size of the?
So, yeah, so this question is only about the site
Okay.
plan. Conditional uses will still go
Okay.
to the Plan Commission and Common Council, and Miriam may expand that more on the natural resource.
Yeah, or like a zoning thing, because I think that's probably going to be the more common thing that happens with those smaller ones.
I think another good example would be, so for example, if there is a natural resource issue that requires there will be revisions hopefully to the natural resource exception process, but yes, you would still see that process. Things that require waivers would still come to Plan Commission. So for example, you have powers over design waivers in PDD 39. So any site plan there would still continue to this board if those waivers are required. Things like that would be changing. There's examples with fences, et cetera. So
Correct. This is assuming that the project meets
meets all
the
of the
standards.
right.
Correct.
If it requires a variance, we'll go to the BCBA
Yep.
or a waiver, we'll go to Plan Commission.
So all the design standards, all the parking, landscaping, all of the new standards of the code would have to be kind of boxes checked for staff to be able to approve it.
Gotcha. Seems reasonable.
I'll tell you what, Dana, to make this simpler,
Yeah.
why don't we just
Okay.
have her sit there? I mean, you're part of the UDO rewrite team. It'll be easier for you. You know, isn't that cool? Yeah, so Dana, when bring it closer to you and just chime in once, just say your name and address for the record and that you are on the UDO rewrite committee team.
Thank you. And again, task force. And regarding the site plan review, I have serious concerns of increase in intensity of uses, impacts from sound, noise, light, things like that. Address, I mean, I know there's parking like that, but that's obviously not what's harming hundreds of people around a certain, so.
So the standards of review do include impact on surrounding uses, natural resource features protection. So we are trying to get at all of those standards. Was there some language in there that you think could be firmed up
Oh, boy.
or revised in some way that,
Yes, it needs to specifically tie into like the municipal code, like ordinance that relates to 7.8, which is which, but there needs to be protections in place.
so this is just about the standards of the
Right.
zoning ordinance.
Right.
It can't pull in the standards from
Okay.
the other sections of the municipal code.
But that needs to be addressed, that there needs to be protections regarding light from any development or any change, like an increase in use, the duration, density.
So that's what would
frequency
be
of
captured
events.
under impact on surrounding uses.
But that seems
And
pretty vague.
Well, Regulo first, then we'll go back to Jackie.
Yeah, just want to clarify that we made a revision to this article. And for example, for conditional uses, if there is a change, we have to process the major amendment and the minor amendment. The minor amendment could be approved by staff, but the major amendment has to go to the regular process, Plan Commission, Common Council, and it has a standard that if the amendment may produce additional noise, glare, odors, or other impacts, it will go to the major amendment process with public hearing, Plan Commission, and Common Council meetings.
Obviously, I mean, we mentioned that there's.
Well, that will be under this standard of additional noise, and it will go to the regular process and public hearing.
I'm just saying, it doesn't, for, in this, you administratively
Okay, so we got it, we have our opinion, and we're gonna keep moving with this.
All right.
All right?
here we go. So the next section is about the natural resource special exception process. And Mary, I don't know if you wanted to give a bit more background on that. But we are wondering whether the proposed to go from the Environmental Commission to the Planning Commission and then not to the Common Council after that. So allowing, again, for more streamlined review. Want to make sure that's something that you all think is appropriate for the city.
Mhm. So this commission may be aware that there is a 3-step process and there is a public hearing requirement with natural resource special exceptions. So they're reviewed by staff for conforming with the requirements of the ordinance. We will have different standards under the new UDO, but there's still something that can be, we can give you clear direction about what is and is not allowed. And essentially this is a variance process. So it does need a decision by a legislative board, which is why it would still need to stay under your purview and not just go back to staff. But having those 3 meetings essentially creates a timeline of at least 90 days for this variance process to proceed. And it can be longer if there are other issues with the site or issues with the boards. It does require a public hearing. So the recommendation is to limit that to the land use board, the plan commission. And I'm open to suggestions about other approaches to limit those number of meetings. We've discussed the combination of environmental commission, but their input is important. They typically have a level of expertise and a level of review where they're evaluating for things like mitigation standards and whether or not those are being appropriately applied. And under the proposed new UDO, there will be potential for credits for mitigation, which a combined Parks Commission and Environmental Commission would be the most appropriate body to make those recommendations. So it is a suggestion at this time, and we're looking for your input because it would mean that the standards, findings, and decision, whatever the document that is the result of this process is, would be your decision. So what do you think about that?
Yeah, in summary, what we're trying to do is reduce the number of meetings from 3 meetings now to 2 meetings. Will be retain Environmental Commission and Plan Commission and remove the Common Council meeting. That will potentially reduce the time frame. Now it could be like 100 days. That could be reduced
60.
60, 90 days, depending on the workload.
Yeah, I support it.
Can you give us an example of one that's been cumbersome in the past?
I mean, they're all cumbersome. in the ordinances, the natural resource protection standards are one of the reasons that this project was undertaken. But one of the things that happens frequently, and happened, for example, with a residential, well, just with an NRSE in the past, is that there was a specific recommendation of required mitigation and a location proposed for it for offsite mitigation, which is something that currently the Plan Commission can create a waiver for, and they are the body that's able to do that. So Environmental Commission can't grant the waiver, and Common Council can't grant the waiver. Plan Commission is the body that has the authority to do that. And the mitigation changed from Environmental Commission, what was recommended and therefore would have been required of the applicant, from Environmental Commission to Plan Commission to Common Council. It went full circle of being, you know, here's the requirements that we are imposing on you, and it changed location, it changed quantity, it changed the type of plantings, and so this would streamline that process a little bit. And we also are developing much clearer standards for that mitigation, or what we're actually now referring to as compensation. We're getting away from that word because it is a term of art in natural resource uses. So yeah, has been an issue, and it creates a lot of burden for developers to try to meet those standards and work up a new plan, which could potentially change.
Mr. City Attorney?
So.
Historically, somewhere around the turn of this century, Common Council created a committee to review natural resources, and after a substantial number of meetings, et cetera, that's how all the natural resource provisions of the Unified Development Ordinance were adopted. And Franklin has been known since, through the years, as the most protective of natural resources, probably statewide. And going through this, I know what the process is, but I kind of, going through the memorandum, it seemed to boil down that, in effect, in terms of the actual existing natural resources to be protected, those standards are basically staying the same.
Mm-hmm.
Yeah. One change to highlight is that the proposed draft will allow for staff approval of impact to some natural resources, like, for example, the isolated wetlands or non-federal wetlands, and also degraded wetlands as defined in Wisconsin statutes.
But I thought I saw something in the memorandum about how those would be maintained to allow for drainage, et cetera, and provide for that. I see Jackie nodding her head yes.
There'll be a set of standards for how to evaluate them. And then if they do need to have impacts, that process, because they are a lower standard of wetland and don't require the same level of external permitting, would potentially allow for staff, if they're able to meet the criteria of the UDO. So in the same way that a site plan, if you're meeting the standards that are set forth, then staff would be able to approve that, but only for those non-jurisdictional or artificial wetlands.
Right. For more detail, the table on page 4 of the memorandum has which natural resources still need the special exception, and what other natural resources may be approved by staff with the site plan process.
So that was our last policy question was, is this appropriate, having some go through an administrative process rather than special exception process?
And I'm a big fan of, oh, go ahead, Marion.
And also the Plan Commission versus all 3 meetings. Yep.
Agreed, and I especially with Marion Regulo here, and if they're in support of it, because, I mean, staff is stretched way thin with a lot, so I want to make their jobs, you know, a little more palatable. I mean, well, it's crazy until we can get a hand on all these boards and commissions, so I'm supportive.
And also during the development of this article, we have a meeting with developers. Some of the input that has been incorporated into the proposed draft.
Yeah, so the article has actually we had a separate meeting with developers over the course of this project. We've met with the DNR as well, and then it has been repeatedly brought to Environmental Commission. So this article doesn't include the mitigation guide or compensation guide. It's going to take me a while, but that is something that's also being vetted by Environmental Commission. And we're hoping that this will make this simultaneously meet those high standards that Franklin has for protecting existing natural resources and compensating for when they're impacted, and make the process simpler for and more like transparent for developers and for the public. So, Gesundheit.
Thank you. All right, good. Next.
Those are our 4 policy questions. That's really the final direction we wanted to get from you all. So if there aren't any other questions or comments about any other sections of the chapter, then that is all we had for you tonight.
So you're not going to go through the whole,
No, we just wanted to go through these 4 policy questions.
because I have a question, so you're discussing like variance. There's some sort of, there's a notation that we, about giving public notice, and it says like 500 feet. Right now, the rocks is notified. So you're going to put in a junkyard, slaughterhouse, something like that. I don't. But when that one
And could you say that a little closer? So you said it's only 100 feet?
it says, I think
500.
It's 500. It's the state required.
500 feet.
Right.
Yeah,
So if you have a 1 acre lot, that's 2 houses.
Well, and to your point, that was an issue with the Strauss project because it only affected a few households technically. So I'm up for addressing that. That would, I'd like to see what your thoughts are, but we have a situation like that where you want to give more neighbors input just because it makes more sense. And with the Strauss thing, it was just a handful that got notified for a community changing project.
Yeah. City attorney can correct me if I'm wrong, but the public hearing notice requirement is set by state statutes.
Mhm.
You can go, you can, that's the minimum.
You can expand it,
Right, you can't minimize.
but in terms of equal treatment, what are the standards
Right.
with regard to the area within which you're entitled to receive mailed notice?
Commissioner Speck?
Is there a possibility to scale it based on the size of the property?
Well, so
So if it's-
the 500 feet would start at the boundaries of the property. So it would be 500 feet from the exterior
You
property.
mean the neighboring lot size?
Oh.
No, I was
Do you?
thinking more
Yeah.
like if the development was, a 600-800 acre
Ah,
development, then it would be required to do 1/8 of a mile, outside their borders. If it's larger, then they're required to contact more people than their immediate neighbor or two.
mhm.
Because I think even stormwater, you have a huge project. I mean, their house might not be flooding it. Hey, should get,
Staff, Marion Regular, what are your thoughts about that? Keep it at the 500, expand it to, or put some more clarification? I'd like to get your feedback on that. I understand what the state statute is.
Any suggestion from other communities, Jackie?
500 feet is already a larger buffer requirement than most other states require. Some it's as low as 250. I think most commonly it's about 300 feet. So 500 is already larger than typical. But if there are specific project types or scenarios, perhaps a certain type of land use adjacent to another type of land use where that could qualify for additional notice, I think that would make sense, but I would want it to be very specific criteria so that, like the attorney had said, we want it to be fair treatment so that it's all types of uses in all circumstances and not just.
I would think any kind
Punitive.
of potential impact outside of the house considered part of how far you. Like
Mary?
a different kind of.
Marion, your thoughts?
I appreciate Jackie's input, and I think there's a couple of different things to consider here. So first of all, the public hearing notice requirement that it be mailed is part of a larger set of requirements related to how these items are noticed. So they're also noticed through the publication of our agendas, and we mail or post notification in a publication of record, which is what's required. In this case, it's typically the South Now newspaper. They're also available on the city website. So we're hoping that in the future we will have a more robust software to allow for tracking the development process, because I realize they're not easily accessible on the city's website, but we'd like to make sure that that's something we start to address in the future. But with the mailed notices, it could potentially arrive at a place where it is prohibitive in terms of mailing to a number of people. If you go out to 1,000 people, I mean, or 1,000 feet, you could be encompassing a huge number of households. And that is something that, given our administrative staff time, even with the reduction that's been, we're working towards with using a postcard, I'm really uncomfortable with allowing that for in every case. However, I definitely hear the feedback that it's appropriate, or would be appropriate for certain types of potentially, difficult uses for people to absorb. So I just want to make clear that A, that there are other things that happen with a public hearing notice, and that B, there is also an administrative burden to consider. So,
Okay, well stated.
And I'll,
Oh,
go ahead, I'm sorry.
Mr. City Attorney?
And it's a social media world. The city could post a new category on the front page of the city website for larger projects of some nature.
Other communities also require posted notice, almost like a yard sign that would go
Oh,
into
yeah.
the property itself. So when you're driving by, you'd be able to see that there's a zoning action being considered. So maybe it's not mailed to every address, but if it's somewhere that you drive by regularly, it's something in your neighborhood, you would see it, you would get notification that way.
Well, I'm going to divert to staff. What do you want to do? Because I know I wouldn't want to be putting out yard signs and other than once every 3 years.
We've discussed that.
That was a
before.
political joke.
We do
You
site
got me on that one.
we do site visits for most applications that are presented before the plan commission. So at the time of the site visit, we can also post the sign. So because I'm concerned about the administrative burden of mailing public hearing notices, that is, we spend our administrative staff and a lot of hours doing
It's a lot.
public hearing notices with the current requirements.
Well, if there's another way, to Dana's point, that word gets out, just for, whether it's on the website, whether it's some sort of yard sign notice, but still, someone's got to do the yard sign, someone's got to print it up. I mean,
It could be a single reusable sign that says this property is subject to a conditional use application, or, and please contact the department, maybe linked to a website.
Have a QR code.
Or another option, just
well, we can get into the weeds with staff. Commissioner
Yeah.
Speck?
Why is the city taking on this task? Why shouldn't the developer, as part of the permit process, be required to post that?
I was going to say that.
Thoughts?
You could have their standard spec saying, this is what is required to be on the sign. It shall be of this size and shall be posted for these dates. And then when they come and apply for the permit. So unfortunately, staff
work.
may have to drive by in order to double check that it's been
Trust but
posted.
verify.
But at least we aren't taking on that administrative burden of
Yeah.
making sure we have enough signs, making sure it's got enough information.
I like that point. We can talk about that a little more. I mean, that makes sense.
At least maybe for the larger developments, if it's just a zoning for maybe a smaller property, have a couple extra, but something to think about.
But if it's something with the magnitude of its own PDD, something of that magnitude, then there's got to be a way in which to get that information out, so people understand that and know that. So those are all good points. I'm going to divert to staff to what you would wish to do, and that's a great point about the developer. But think about, we've got, this is, we're going to try to figure this stuff out, but somehow, if I'm down with you, down in planning, with everything going on, it's what you think is the best route for you.
And then, like, the different,
They are.
They have to
Oh,
be.
for sure, yeah.
so it should cover that. I do have other comments on other people. So, you saying that this is the way it's been.
I would say recommended.
When is the public?
Regular?
We don't have a date yet, but we're looking potentially for November.
When it cools down.
Because there's lots of I have comments about like you things. There should be additional, like one of the things. And video, it says that for. Franklin. Is in review the site plan. Obviously, there should have been. That kind of, obviously, that was. I think it was- Oh, and then there also should be a comment, this is from the existing. Zoning administrator or city planning department for any application. Review all for the designated that the application involves issue of determination as to whether the proposed use or required, but that there is a question of whether proposed affect adjoining property due to the nature of noise lighting at the
So
I
we're
think that should be.
regarding the application requirements in the 15901B, we have the filing section. So it says application shall include all information, plans, and data specified in the application requirements manual. So that would be a separate document, non-codified, that can be updated as needed. So there aren't any application requirements spelled out in the UDO.
I'm just saying, there's the opportunity for restriction to defer, which is what.
So
they
the
do.
application manual would spell out all of that as well. Yep, that's referred to right there.
Thank you, Jay.
I don't believe so.
No, not yet.
Okay.
Okay, where are we at now with this? Is this, are we,
Yeah, I think we're just taking comments, questions, discussing anything you guys want to continue to talk about.
staff?
No, I don't have anything additional.
But you're good?
Yeah.
Commission?
I just had a question. Are we adhering to the schedule that we got in the rewrite here a couple months ago where did we have the public open house in August? Was that the meeting we had over in the other room?
No, yeah, we may be like a couple of months behind of that original schedule that was set in January. Yeah.
It said a public open house in August. And then review by the attorney, and then a public hearing in late October or November.
No, yeah, that's not longer current.
Okay, so
Yeah.
we're gonna make changes.
Yep.
Okay.
But we have had the attorney review the document, so it's going to be a more complete document that's brought to the open house. So we wanted just to have a more finalized document that's made public at that time.
Okay,
So we're looking at November for the open house.
okay. Somehow I think we need to plug in Dana, Debbie, and Kristen to things like that schedule, since they're trying to adhere to that, right, Dana? So,
Yeah, just for information, we had two focus group meetings with Dana, Debbie, and
remember that.
Kristen. Yeah.
Would be nice to get, I mean,
The Environmental Commission has reviewed the section many times.
I'm just saying versus comments.
I think the
They're volunteer
Environmental Commission is all
residents of
citizens.
Franklin.
Agreed. They are.
Yeah, they are.
Yeah.
You got to be on
Yeah.
a commission here.
So if any, is there anything other comments on this? Because if not, we'll do a motion to adjourn.
I have a question. I was looking at the City of Madison conditional use, and they go through a lot of regarding affidavit that the developer agreed to all conditions, approvals, special details. I did have a question about the fees. So for example, there's 39 amendments meeting for a developer. You guys get $100 for staff.
The,
I asked at the previous meeting.
the fee schedule was updated last month
Right, no, but I'm saying that for each major.
for each application. Yeah, an application may include
More than one.
more than one
I
amendment.
know, but
Yeah.
if they have 39, I think should be the limitation. One application. Do all those.
I will say that that's like an outlier. I mean, like a case, red case, but typically it's one or two
No,
amendments.
that's why I
Yeah,
say, that's why I thought it should be clarified.
yeah.
I understand. Usually.
It's a fair statement. Mr. City Attorney?
With regard to the conditional uses, through the years,
You're on.
No, it's on. It's on.
You're good.
here and there, get a question from a developer, is this a conditional use? I said, it's a special use. Well, a conditional, why is it called a special use? I always said, because Franklin is special. So now we're changing the name? All right, statutory.
Yeah.
All right, and everybody else.
Yeah.
There goes the unique nature.
So I do have a question. If a development is as a, is there a way for it to no longer?
If it's no longer meeting the conditions under which it was approved, the conditional use can be revoked.
Or if it's discontinued for more than 1 year.
But other than that, if it was.
Yes.
Does the conditional use, especially, needs to be that.
Be careful. Be careful how you answer, because we all know where this is going.
Parcel, property, especially.
And if you
I
did,
didn't see any clarification.
Are you saying if the changes to the UDO would now allow a use to be permitted where it was once conditional? Is that the question?
I didn't see any of that in here, so I was just. How is that?
I guess I'm not fully understanding the question.
Something is approved, especially years. Then a
So it was
large
rezoned, or I'm not sure
No, not
if I
really.
understand
No,
this.
it's just-
Is there a specific circumstance you're referring to?
well, we all know.
I think the attorney has a comment.
Mr. City Attorney?
Planning staff, do you recall ever limiting the term for a special use? I don't recall that occurring.
No, not in a specific case.
Well, that's
how's
the
that not-
hypothetical question. Doesn't occur.
I don't think we understand what your question
I was
is.
just curious.
I don't know.
Okay.
Is, might as well bring it. You want to bring it, you're on record, bring it. Because we're going to be done in about 5 minutes here, so.
I'm just saying, obviously, Roxbury. Especially the condition and. I've yet to figure that out.
Thought they were a planned development. No, if you're a planned development, you're a planned development.
It may have been that it was superseded by the PDD, that they had a prior approval. I don't
No,
know.
the PDD.
Okay.
Don't know, but we're not gonna figure it out tonight, so whatever your questions are, staff can follow up and, or city attorney, whatever. More than one bug here. All right, so now, if there's nothing else, we'll take, anything else from the commission? No, entertain a motion to adjourn.
The movie adjourn.
Second?
First and second, all those in favor?
Aye.
Mayor votes aye.
Thank you.
Adjourned.
Hey, that-
Absolutely, 6:45, you let me know when we're off record, regular.